Good afternoon, everyone. We're here with Brendan Long, Principal of Celtic Legal, based out of Brisbane, who is with us today to talk through some of the hot topics that we're seeing around questions on the legal situation and the environment that we're in. We've had a number of questions that have come through in advance from folk who can't join us online during the session. So Brendan, if you're happy to take those, we'll run through those as well. Just by way of housekeeping for everyone, if you want to use the Q&A or the chat function to send me your questions, we won't do live mics just to keep a bit of order. And I will ask your questions anonymously. So do feel free to put the questions through. We won't read out your name in the recording. We'll just put the question to Brendan. The health warning, as always, when we've got lawyers on these sessions, is that the advice will be general in nature and may or may not apply to your specific circumstances, and you should always make sure that you get detailed legal advice for your own situation. But like the two themes that we were going to focus on today were around debt recovery and also employers' responsibilities. So looking at the debt recovery, Brendan, feedback that we've had is it's maybe a new thing for a lot of businesses to find that they are starting to worry about the recoverability of debt. And there is a lack of awareness in terms of the process and what happens. Feedback has been that, some people are saying, well, this is generally a good customer. They're having a bit of a tough time. I feel a bit bad about going legal, but what's involved, what happens. So, from I make the phone call to you to say, Brent, I'm worried about this debt, what happens?
Yeah, thanks for that, Barry. Look, debt recovery is and bad debt, generally they're dirty words because nobody wants to have them, nobody wants to have to do it, and everyone wants to give the impression that they don't need it, that their clients are so good and they have such a good relationship that they don't never need to action it. And that's obviously never the case, and particularly more so now. A couple of things. Firstly, when I would get that call from you, the question would be, well, how far over is he, or is it just a suspicion? So if you give the example that you ring me up and say, oh, look, John, he's a great fella, but he's gone overdue now and I'm worried. And once I dig deeper, I might work out that, well, he's actually 90 days, 120 days plus. The so-called good fella, by the end of the conversation, I've worked out he's not really a good fella at all. He's always been stringing you along. He's been using you as his funder or his bank, and he's just been giving you enough to get by, to hold you off, and all of a sudden now you're owed 70 or 80 grand, which going back maybe possibly to the end of last year. So that'd be different to the type of situation. And on that one, you'd definitely be looking at taking some action, and I'll come back to what action that might be. The other one might be where someone has approached you within terms to say, look, Barry, I'm struggling. I know you have 14 days and this is day 7, but I'm not going to be able to make it on day 14. I'm just letting you know. And you might ring to say, well, that's not good, and all of those things. So working backwards on those situations. If someone has approached you or you're worried about someone, the first thing is definitely to reach out and talk to them by phone, or call around to them if that's the type of relationship you have. If it is that you're worried, then a client would love the opportunity to speak to you and tell them, tell their side of the story and say, look, I know I owe you 50,000, but I'm just not going to be able to pay it. If you're the first one and you're reaching out and you're personable about it, the most likely scenario is that they'll say, I'll get you what I can. I'll get you 20 now, I'll get you 10 the following week, and a fortnight after that, I'll get you the balance. So all of a sudden now you're working on a guaranteed cash flow. You're going to get at least 20 grand of it in, and you've got an arrangement for the other 30 of that total debt. So the most important thing on that is to follow it up in writing and just confirm, hi John, just confirming we'll get this sorted like this. That'll do a couple of things. One, it gives you a little bit of certainty of cash flow. And if you can do that with a lot of clients, some of them will simply say, yeah, no problem, we'll have it paid in full. Some may not take your call, and you made an argument, which I'll come back to as part of that phase one. But you'll be able to have a little bit more certainty as to what you're getting, how to plan revenue, which of course will be very important when you're applying for JobKeeper as to revenue projections and things like that. If you have that type of relationship, the clients that you end up in 6 months' time that you have seen through and work with, they will stay your clients. The clients then are the other ones that they've actually been outstanding for a long time, or when you've rang them, things haven't gone as well on the phone call. You've got to work out what you want to do. So it might be new to a lot of businesses in that normally it's just accounts rings and they just hound somebody on the phone and eventually it gets paid. That's probably not going to work now, because if you're doing the phone to him, this particular guy, there's going to be plenty of people, or you're just not going to get an answer. So the first step might be to do a letter of demand on from any lawyer to send out a letter of demand. There might be 48 hours to pay or 7 days to pay, and then see if that gets any response. Often a lawyer's letterhead has a little bit more of an effect than people think. It does show that there's action going to be taken. Hopefully, if there are terms of trade or some sort of written terms between the two of you, then that'll be the first place to look at after that. So hopefully that will give you some rights as to what you can do and where you might go with it. So, for example, the rights might be very, very harsh all the way down to pretty watery. So harsh ones might be that you have a director's guarantee and you can access the director's personal property, such as a house, and that you can put security over that house. It might be that you can appoint a receiver over the business. So, for example, if you're a wholesale meat supplier and your client is a butcher and you know that it's a busy butcher and you know this guy's ignoring you, you might appoint a receiver in there knowing that you'll get your money the hard way effectively. So you'll appoint a receiver. The receiver will go in there, collect what's owed to you, collect his fees and exit. And doesn't care about how the business is left. And more than likely, that'll be the end of your relationship with that business. So that's something to keep in mind with the very harsher steps and the stronger steps. How much money is it? And do you want to continue dealing with this client? If it is a case that the debt amount is so big that you simply can't ignore it, and it doesn't matter how good a guy this guy is, if he owes you 200,000-300,000, you have to take action, then you definitely need to be looking at those types of strong actions. Similarly, with the security over property, all of the legislation that's brought in with respect to evictions, for example, they don't affect debt recovery and insofar as how to sell the property. That's because there's no tenancy agreement between you and this particular client. So if you were to take security over a property, you could enforce it by way of sale of that property effectively. So you wouldn't be stopped from doing that by any of the new legislation. Winding back further, then it might be that you just decide to issue a claim out of the relevant court. So whatever state you're in, the monetary jurisdiction will change between the magistrates, the district and the Supreme Court, depending on which state you're in. Anything under 100,000 generally is in the lower court. Now that changes on the states. And the lower courts, all of the courts are still functioning. It's just the personal appearances are not happening. So, for example, mediations are still occurring out of the Queensland courts. It's just all done by telephone. Appearances are being done and mediations done out of New South Wales Supreme Court by video. Federal court mediations are being done by video for any matter that needs to have a mediation occur. So the court system hasn't stopped. It has definitely slowed, and there's a real backlog because of various reasons. But the court system is mainly an online filing system in most states. So we can file something online and get it back sealed by the following day and have it out for service and get the time ticking as to if you've decided to sue somebody. So there's no real delays in getting things issued. As regards the final hearing of the matter, that would be probably a little bit longer than expected given delays. But just because you're hearing that there are backlogs everywhere shouldn't be a deterrent to issuing proceedings when you need to.
And in terms of that mediation process, do you tend to be part of that with your client, or is that really, the supplier and the customer, not that out in camera with someone from the court system?
Normally, the lawyers would be in attendance on both sides. So with Zoom, you can have the breakout rooms and all of things like that. So someone like yourself might be the mediator. You hook people in and out, and you talk to each side. And probably we've done maybe 3 by phone and 2 by video in the last 10 days or so. And they're as successful as a regular mediation in that it takes 2 to tango. If one side is coming to settle and the other side isn't, it's going to be tricky. If both sides are there with good intentions, a deal will be taken, a deal will be done. The biggest thing on those is, and this is similar with any agreement, if you reach an agreement, it's getting it signed is a little bit trickier at the moment with a lot of people working from home. So for example, if you and I cut a deal right now, I need to make sure that you have some facility of signing off now and getting it back to me. So if you don't have a printer, we need to work out a way that I can send you an email and you can reply and agree to those terms. Obviously, the ideal scenario is I can send you a one-page deed or sets out the terms. You sign your name at the bottom, scan back. I do the same, and we have a signed document. But if there is not that facility, which is completely fine, even people that are on at this stage, everyone's got emails on their phone. You can send an email, draft it up, send it, get the response. That's an agreement.
Right. Okay. So the system's still working. In terms of, in your experience in those sort of small business mediation situations, are they more likely than not to result in an agreement, or are they generally just there just in case before you get into the main course?
I would say probably 85%, 80 to 85% of them are successful, and success might not be settlement on the day, it might be within a week or 2 afterwards. There's always, the odd 10, 15% where they're just never going to settle. 2 people that really hate each other. If one guy said today was Tuesday, the other person would disagree. Those ones are never going to settle. Those ones going in and you're prepared for them. They're just a step that you have to take to get it done, basically. Often the mediations and any settlement discussion, they bring up things that, from our point of view, our clients might have either forgotten or not known about. So there might be, for example, I'll use my meat supplier again, an allegation brought up at a mediation that, well, there wasn't, there was supposed to be 4 tons of pork delivered and there was only 3 tons, and there was another bit just that was not saleable. And we go back over our records because it had never been raised before, which is never ideal, but happens all the time. Never raised before. The other side's lawyer has picked it up and said, well, why haven't you complained about this before? We go through our records and work out that actually our 60 grand claim is actually about 40, and we might settle for 40 on the day. And that's on the basis of this information. So when used properly and everyone goes in with an open mind, both wanting to put forward a strong case, definitely wants to get their point across, but open-minded as to both the other side's view and trying to get a commercial deal, then they are successful. And the other thing we are finding is that certainty of money now is far better than winning a trial in 6 months' time. So, for example, settling a matter that you'll win 60,000 on for 50 today is better than winning 60 in 6 months' time.
Right. Okay. And attitudes are starting to move in that direction then?
Yes, definitely. Both sides, because if you're suing someone and they're struggling, the last thing they need to be doing is paying their lawyers to drag a matter out. They need certainty one way or the other. The last thing any business wants is for a legal battle to be that which sinks its ship. They would much prefer it to be their own mistake or circumstance. Don't let lawyers be the ones and lawyers' fees be the ones. So there's definitely a lot more approachability on mediations probably in the last month, and I'd expect it to continue for another 2 to 3 months.
Okay. A question that we've had in around directors' guarantees. There are some big announcements about access to, $250,000 over 3 years as part of the SME guarantee scheme, where the government's underwriting half the debt. Great announcement, but what maybe was missed is that the directors are still going to be responsible for the other half. We had a chat about this before, and you were saying that, if you're representing the lender, you're going to look for as much security as possible. If you're the borrower, you want to have as little as possible. In those circumstances where business owners are thinking about accessing schemes like that, at what point do they have the conversation with you? Is that something that they do themselves, or are you called in via the accountants just to give the agreements a once over? How does that work?
It could be a matter where we're involved from the start, or the accountants call us in to get something drawn up. But how it would work would be, for example, you've applied for your loan, so that means you're going to be in the gun personally for 125,000. That's what your risk is. So what you need to assess is, can I afford to basically write a check for 125,000 to pay this back at some stage? Am I just getting this loan to push off the inevitable? Is this going to be a problem down the track and I'll just be 125 grand personally in a hole? Or is this genuinely a short term where this will see me through? There's work in the pipeline. I need this for capital. Or trade overseas is obviously, maybe you're reliant on that, and that's blocked off, but the trade routes will open to New Zealand or wherever, or I'm going to diversify, but I need this to purchase new plants to be able to do that. Those are the kind of questions that should be asked immediately, not just a rush off to go, well, there's 250,000 of free money here. As you've said, you're going to be in the gun for half of it at some stage if it can't be paid back. And just because the interest rate is low doesn't mean that the principal still isn't hanging around there. With regards then from anyone that's signing off on that loan, the biggest thing to look at then is, what's your asset protection? So what's your asset base? What do you stand to lose? If, as a director, you have a personal home that's in your own name, you've got a car, you've got an investment property, things like that, then it's definitely a risk that you need assessing. And probably you need to look generally at how you're structured. Have you got a family trust? Where are things structured generally? This could be a good kicker to talk to your accountant or your lawyer to say, look, I want to get this. I've just realized my risk profile is quite high because a lot of things are in my name, and I need to work out a structure and to get the most protection for me and my family. So that could be a good kicker, and then you put that in train as well. With regards then to personal guarantees generally, the other thing is, you got to assess how many of you already signed. So if this is, if you're deterred by this, but then when you look at it and analyze it, you've actually signed one for your lease, you've got all your suppliers, and you're currently already, you've already signed maybe 5 or 6 personal guarantees, which you're on top of, but you've already signed. Don't let the personal guarantee be the deterrent, but definitely get informed advice to make sure that it's for the right reason. You're not going to just spend it fighting a losing battle and saving it. It is going to be paid back, and what you're using it for is going to find revenue to pay it back. And also, it's a good time to have a critical look at your own asset structure personally to see, why was I not set up better to be able to access this?
Okay. Coming out of the debt recovery and looking at employers' responsibilities, what are the changes to, if any, of employers' responsibilities where staff have been used to coming into an office, are not critical workers, therefore are working remotely? How does that change in terms of the legal relationship and responsibilities?
Well, obviously, if you have not already, and you should have hopefully set out to the employee to make sure, a little checklist to make sure that their working from home space is free of any of the same hazards that would be in an office. So it's not got trip hazards, it's got ventilation, it's not open fires, open electricity cables, all of the usual things that you take for granted when you walk into your office. you got to make sure that whatever room is set up or whatever workspace is set up at home this is down to each employee, but each employer should make sure that they've given this notice and got the feedback from each employee that, yes, I have done a self-check of my home working space and it fulfills the criteria you've set out to me below. And if anyone hasn't done that, I definitely encourage them to do that straight away for two reasons. One, for safety, and two, it protects you as an employer to make sure that you have something to rely on, that you have done the right thing by your employees. As regards then any problems that have been encountered after you've done that, unfortunately, this is all very new, and certainly when if somebody asked you were going to work from home and told you you were going to work from home for a month, you wouldn't have believed them. So people might be set up to work from home a day a week, but not necessarily 5 days a week because of a construction site, children, or just maybe health issues or whatever it is. The most important thing in this is communication. So hopefully you're able to reach out to your employees through either yourself or HR or particular regional managers to make sure, and it's important to touch base on this as well, make sure everyone is tracking okay. Because if somebody is isolated and perhaps living in a more rural area, it's important to reach out to make sure the mental side of things are okay as well. Because if somebody is living on their own and hasn't seen somebody, gets things delivered, hasn't seen somebody for 3 or 4 weeks, maybe it is important to set up a Zoom meeting with them or something like that, just purely so that they can actually speak and see someone's face for a change. So communication is the most important thing that I would definitely say to employers, to talk to employees about any challenges they're going through, and even anything that they would change if they had the chance again.
Right, okay. One of the sessions we ran a couple of weeks ago was a virtual assessment of ergonomics, because it had come up in a few conversations with member companies that there was a bit of a concern, people who weren't used to working from home were being, in some cases sent home with, the monitor off their desk and best wishes. And there was just a fear of a slew of work cover claims coming through on the back of that in terms of people not being set up correctly. So, would that sort of assessment be reasonable in terms of an employer getting on the front foot? Or would you feel that it was potentially seen as intrusive?
No, 100% reasonable. I think it'd be very difficult to say that it was intrusive, given that if one of the employer's obligations is to provide a safe workplace for an employee, and that would be part of that under the Fair Work Act. So it definitely wouldn't be seen as intrusive in my view. And definitely looking out for the employees' benefit, not necessarily for the employers, but definitely for the employees' benefits. So I think that would reflect well on the employer.
Okay. In one of our earlier sessions, we talked about, the different phases that this might go through. And, we've had a few weeks of effectively crisis management, a lot of companies just making it up as they go along. Some have managed to get good advice in and start transitioning people. We're now moving into that second phase where this is the current normal. Goodness knows, exhausting as they may be, we're probably all doing multiple video conferences every day and enjoying how we're aging in front of our own eyes. But there is a rising concern in some member companies about productivity and managing performance going forward. So if we are like this for weeks and months, I'm in Victoria. We are unlikely to have the kids going back to school this term. There's a lot of distractions. Are people being as productive? There's a nervousness about it being okay to have performance conversations. How would you feel about that?
Yeah, and that's understandable given that it's a sensitive topic. But luckily now, everyone, coronavirus is obviously, it's here, and compared to where we were a month ago, or 6 weeks ago, probably more accurately, it's now a real reality that this is a problem in the workplace and has caused to work from home. As I touched on, as an employer, you have a responsibility to provide a safe workplace to the employee. If that workplace happens to be at home, then the same rules on productivity apply. On the proviso that you have been able to provide the employee with similar facilities. So if an employee is incredibly productive at work because they work with 7 monitors and 4 computers and have 3 receptionists running around, and now they're working off a small laptop at a cramped desk, which you already know about, then, but you know that this guy is a good worker, and you're happy to, you were happy originally to have that arrangement, but now you're working out that productivity is down 50%. Well, that is a situation, that's a conversation that would need to be had quite openly with the employee, as to let them know as to what your barometer of productivity is and why they haven't met it, and also discuss with them how that might be achieved, and to take on board the feedback. So whether it is indeed an employee issue, an employer issue, a little bit of both, or some factors outside everyone's control. So a factor outside everyone's control is just that the workplace at home has become, something is happening in the neighborhood, and the NBN just isn't giving the connectivity that you need. So probably need to work out, is there a dongle or something that can be given to get more connectivity. If it is a thing that productivity is low because of something the employer can influence or hasn't done, then certainly can the employer do it? So can we get another screen shipped out to the person? Can we get them a new laptop, whatever it is? But the employee also then needs to be aware that this isn't just a carte blanche where you can just get up and roll out of bed at 20 past 8, turn on the computer at 8:30, send that group email, hi guys, I'm logged in, then head off and make breakfast and come back at 10 o'clock. Whatever way metric and barometer is of marking performance, whether it's a timesheet or a task sheet, then that still applies. And if it's not being met, then similar criteria would apply. A discussion on it, probably an informal discussion, then a formal discussion, whether you want to do a formal warning, written warning, and then a final warning. So your employment contracts with your employees will probably set out, and if you're a larger company, you'll have a HR department that will have the criteria set out. The same criteria applies if performance isn't being met, and it is not, and it is down to employee performance, not outside factors or the employer.
Yeah, it's certainly been a surprise over the past few weeks to discover how many companies that maybe, who are in that smaller end of SME, who don't have an in-house HR department, are starting to scratch their head and wonder, well, how do you have a conversation about performance management when our contracts aren't in great nick, or job descriptions? Well, Johnny was hired to do this, but he's actually doing that now, and things like that. So would you work in conjunction with HR practitioners who would go in and assist a company to sort of get the structures right?
Yes, and I think the most important thing, if that's the case, is for hopefully that director can maybe realize, is it something within my skill set? Because most directors of small companies they're the debt collector, they're the accountant, they're the bookkeeper, they're the HR, they are the everything for their 6-7 employees, which sometimes is 3 and sometimes is 14 employees. So completely understand that they may not, and often jobs that were done on a handshake and things that were done by a one-line email 6 months ago aren't as effective now, and it's always difficult to rely on something when the job that your junior accounts person was hired to was actually a 2-day-a-week, filing clerk or something. So, and we've nothing showing the progression other than a pay rise, and some discussions which we didn't keep notes of because we're a small business and we just got it done. The reality is that it's still that you just have to be very wary and sit down and say, look, Barry, as you know, this is the role you were promoted to. This is what we expected. And unfortunately, you're not meeting it for this, but we're happy to work with you. it would be more of a tentative conversation because you don't have that backing of the written document to say this were always your duties. But that doesn't preclude a conversation from happening. And if it is something that, for example, yourself, you wouldn't have been comfortable in doing, then certainly you can get assistance from lawyer, accountant, or somebody like that to do the draft up, or to attend with you, or to even control the whole thing and have that discussion as an outside person with that employee.
Okay. One last question that I had in from one of the member firms was around the awarding of contracts. There seems to be a little bit of a freezing up in some areas, particularly around some construction work, where the client is getting a little bit nervous about appointing someone to carry out the work due to concerns around their potential insurance cover and liability of community transmission if they're bringing in work crews into a site, etc., etc. How do we work with business owners to try and give them that comfort that they can actually proceed to award work, that they can bring people on site and get things done?
Well, I suppose the first thing for anyone that's holding off on awarding a tender is just make sure you're not in breach of your own tender process. So make sure that if you haven't wrapped yourself into something that says we will award the winning tender by no later than 1 April. So just make sure that and hopefully nobody would have done that, and that there's enough clauses in there to also say that we can extend this if we see fit. With regards to the actual awarding, the biggest danger is always, of course, that there's no work being done on site, and there's claims for liquidated damages for delay flying around everywhere. It really will depend on the industry as to how big the site's going to be and what processes you can put in place. If any company has tendered for it, be quite open in dialogue with them and say, tender conditions have changed from when we opened this on the 15th of January. Can you outline to us in no more than 2 pages how you would react to and how you have put in place social distancing measures, and how you would react to having your team off-site and fly in, fly out, and how you would react to that. So if you can talk to each of the tender companies and work out from them what have they put in place, so you can work out who is best equipped or not equipped at all. So it might be that your preferred or the one you were thinking was going to be your preferred choice has actually made no attempt to do any of these and was going to be a bad risk from a planning point of view, and that you can actually use this opportunity to see how well planned each of these tender companies is. But I'd be definitely finding out from each of these companies, what are their processes, what have you put in place? If you're awarded this contract, what are you making sure, and what commitment can you give us that you will be able to work without community spreading? And if there is an outbreak of one, how you're going to minimize it.
Okay. So it sounds, in all the topics that we've covered, it sounds as if early communication, regular communication, clear communication is the key. Whether it's the debt recovery, the looking after your employees, working with suppliers, and I think one thing that I would take away from it is if business owners are worried about having some of those conversations themselves, or feel ill-equipped to have those conversations themselves, to pick up the phone and speak to you or whoever their lawyers are, is probably quite a common thing for you at this stage in time. And there's no shame in getting a hold of people and getting good advice.
Absolutely agree. Early communication was always important. I think it's now the key, and whether that is communication with people to find out if there is a dispute, and then when you find out there's a dispute or a problem or a query, find out who's going to be the best person to help you, whether it's an accountant, a lawyer, an engineer, and get that advice early. Because if you let it fester, there's going to be two problems. One, it'll get worse, and two, you'll start listening to and looking at Dr. Google and finding out all the things that you could do, and you might be right, and all of a sudden you've got 5 options and none of them might actually be the right one.
Okay. All right. Brendan, we've run a bit over time. Thanks for bearing with us while we got through those questions. Thanks for everyone who's joined us today and who'll be watching the recording later on to see if their question got answered. Hopefully we didn't miss any of you. And look forward to chatting to you again soon. Thanks, Brendan.
No problem. Thanks, Barry.
Yeah.